Zoom meetings on the income tax topics. Today we have a very important topic, which is a practical aspects regarding assessment and appeal proceedings. So Mr. Gaurav Jain is the advocate who will be speaking today on this subject, and he will be giving highlights of all the issues which have arisen out of the assessment and appeal proceedings in faceless regime, and will also be giving guidance how these matters should be handled in the assessment and appeal proceedings. This is purely a practical aspects, as we have seen in the past that after the assessments were done in the faceless manner, so many issues had arisen and matter have gone to the High Court in so many cases on various issues, that section 144B has not been complied, or instructions of CBDT have not been complied, or the process of the was not there, proper opportunity was not given. So all these difficulties have been there. So how we should look into those issues and how we should handle this, Gaurav Jain will be handling. Gaurav Jain has a long experience in handling matter. He has been with West Associates for more than 20 years, and now he's on his own, and he's a very handling the matters of very important clients of Delhi, and he has been appearing regularly in the High Court and Supreme Court. So this is why I have requested Mr. Gaurav Jain, and I am thankful to Mr. Gaurav Jain for agreeing for giving the deliberation on this subject. So now, firstly, I will request our President, Mr. N.P. Jain, to give his opening comments, and then floor will be of Mr. Gaurav Jain.
Thank you,
Jain sir,
Gupta ji.
please.
Thank you
Yes,
very
please.
much.
Yes.
And you have seen that we mentioned Advocate Gaurav Jain,
Yes.
but he is both an advocate,
Chacha.
but he is also FCA.
Yes, 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 yes.
First CA, sir. First CA. First degree is CA.
So we are glad that CA and Advocate Gaurav Jain is with us. There are many issues which he will deal, and at the same time, when we discuss with the departmental officials, many of them are themselves not happy with the faceless regime. Likewise, many tax practitioners and taxpayers are not happy, because in appeal also many times even the written submission response is given not only once, but they are asking again and again, twice, thrice, but still the orders are not being passed. So these are the problems about the department. I think the Honorable Prime Minister was informed, rightly or wrongly, that there is a lot of misdeeds. So all of a sudden they came out with the faceless regime. And one aspect which we need to consider is that the faceless regime is also monitored by the revenue authorities, be it Joint Commissioner, Deputy Commissioner, Assistant Commissioner, ITO, or Commissioner. So they are basically the representatives of the revenue. And in some cases, people are getting relief, good relief. But in many cases, the relief is not as expected. Even the case is not being properly considered. So in this kind of scenario, Gupta ji will also take care as to what we should represent before the government.
और एक डब्बा मंगा दो अच्छा से, और एक बार बीच बीच में थोड़ा छुटा है ना, उधर भी केक रख दीजिए.
So that the difficulties which are people are facing, that can be taken care of. I will not take much of your time. We would like to listen more from our learned speaker. So I once again welcome you all, because our friends have joined from all over India, and many more are in the process of joining. But we will not wait. And as it is suggested by Gupta ji, we start in time. So Gupta ji, you can hand over to Advocate
Yes,
Gaurav.
Mr. Gaurav, please take over.
Yes. Thank you, Gupta ji. First of all, I would like to thank the AIFTP, which is a very well-known tax body of the entire country, for making me part of your entire members, and not only making me part of you, but giving me opportunity to share my thoughts on the subject of the day today. And moreover, to my very dear Shri VP Gupta ji, sir, no need for you to thank me, to be part of here. In fact, I should be thanking you for making me part of this. And incidentally, sir, the topic of the day matches with your initials, VP. If you would want to ask me how, I would let you know. VP for me would mean virtual proceedings. So this is the topic which we are discussing today through a virtual mode. So that's why how you are always relevant, sir. And I thank you once again. Now coming to the topic, I think what we are discussing today is faceless assessments and appeals. The entire globe is moving to a digital era and electronic mode. So India could not have left behind, including our tax department, and therefore the now the entire shift has substantially happened, not 100%, but to large extent, the entire procedure of assessment and first appeal is majorly shifted to this electronic mode, and many more pending gaps are yet to be filled. But having shifted to this electronic mode, we have to deal with new modes and methods of practice. The new era is posing us new challenges. Various kind of legal issues are being thrown up, which are yet to be resolved. Partly, courts have come to our rescue to understand the new mode of communication. For instance, service of notices, issue of notices through electronic mode, how far they are valid, or what would be the timing of their issue or service, validity of document identification number, how far it is valid or it invalidates the relevant notice or the assessment order, and the manner of representation via electronic mode, either through virtual hearing or through filing our submissions online. So a lot of issues are open. Uh, when I review my talk of the today, what I clinchingly observe is that because of this new mode of assessment and appeals, I think the role of courts have substantially increased. You would see there are we have to time and again took defense of writ petitions and approach the court to correct, to merely to get correct the errors which are happening just for want of a proper mode of assessment or appeal in the electronic mode. And secondly, Narayan ji touched in brief, when it comes to appeals, there is huge pendency on that ground, which is surmounting and is not coming down at all. I think at that front, the organizations like AIFTP under the leadership of Narayan ji, VPG, would need to take up active role in liaising with the government in finding solution to the surmounting pendency of the appeals at the first appellate levels. With that background, friends, I'll be continuing with my talk of the day. I'll be touching upon the statutory framework prescribed for various aspects of electronic proceedings, be that of assessment and appeal. I'll proceed stage by stage. We'll discuss the statutory framework of each stage. What are the challenges being faced at that stage? What are the current judicial position, divergent views of the court on that particular position, and open issues or precautions that needs to be taken at all these various stages. With that background, friends, first I'll give you a brief overview as to the genesis or source of the present system of faceless assessment. Certainly, it was the brainchild of our Honorable Prime Minister when, in the 2016, he gave a manifesto of a rapid and an accountable income tax department, which included more focus on digitization. It was that thought which has over a period of time led to evolvement of electronic system. Originally, friends, it came only as a pilot project, as a e-assessment scheme in 2018 and 19, and which was there even till beginning of 2020. E-assessment scheme was an amalgamation of faceless assessment and a physical assessment, in the sense that it was not completely faceless, but it was more of an electronic assessment where I knew my officer. The only difference was that the assessee was not required to physically appear before the assessing officer, and he was empowered to receive notices over email or on its ITBA portal, and he could have filed his reply over email or ITBA portal, but he knew who his officer was. It was during the COVID time when that TOLA, that Taxation Ordinance Laws Amendment Act, which was an interim measure, an interim bill passed by the government during the COVID time, that this complete faceless assessment scheme was introduced through insertion of a new provision called Section 144B of the Act. 144B deals with the entire mode of faceless assessment. I'll come to finer aspects of that section, but to briefly touch upon what is the difference between the e-assessment scheme that prevailed prior to 2020 and what happened after 2020 in faceless assessment. The e-assessment scheme was only applicable to regular assessment under Section 143(3), whereas the current provisions of Section 144B, that is the faceless assessment, is not restricted to 143(3), but expands to reassessment under Section 147 also, and best judgment assessments under 144 also. And there are certain exclusions to this faceless assessment, that is, assessees having jurisdiction of international tax, that is the non-resident assessees, or assessees having jurisdiction with central circle, that is an assessee whose case is centralized with the central circle, either pursuant to a survey or a coordinated investigation, or has been subjected to a search and seizure. If his case is transferred to central circle, then the assessment happens physically and not through the faceless mode. Now, TP assessments as of today are also not subject to faceless assessments. They are happening physically. If it's a case of a non-resident assessee, then the entire assessment happens physically. That is, both the TP assessment as well as the regular tax assessment happens physically, because that's an exclusion under Section 144B. But if it's a case of a domestic assessee having an international transaction with a foreign company, or a specified domestic transaction covered within domestic transfer pricing, then it is only the TPO proceedings, transfer pricing proceedings, which happen physically. Then the NFAC will make a reference to the TPO. TPO conducts TP assessment physically, then gives the order to the faceless assessing officer, and from there it is the faceless assessing officer who takes over and pass the assessment order through a faceless mode. As I pointed out earlier, the other difference is that in the e-assessment, we knew who our officer was. It was the jurisdictional AO only who was conducting the actual assessment. But yeah, the mode of communication was electronic. In the 144B faceless assessment, as we all are aware, it is conducted through a central mode, that is National Faceless Assessment Center, which is held by various units, that is assessment unit, review unit, technical unit, etc., etc. We'll see it later. But we don't know who is the officer behind who is conducting the assessment. Our jurisdictional officer has no role in conducting the actual assessment. He is only a nodal officer to do ancillary things relating to rectification, processing of refunds, or in case of any difficulty, he could come into play. But he is not the one who is conducting the assessment. Then in the e-assessment, draft assessment order was to be given only in case of 144C cases, that is eligible assessee where TP or international tax case was involved. There was no provision of draft assessment order. In a case of faceless assessment, Originally, draft assessment order was to be given even to the assessee, but post amendment in 2022, a draft assessment order has to be passed by the AO, which will be a subject matter of review by the review unit, but it is not given to the assessee. Assessee is only provided with a show cause notice, where if any adjustment is proposed, to which assessee can reply. But there is a provision of draft assessment other than cases of eligible assessee. So if an assessment is covered under 144C relating to a non-resident assessee or a issue involving transfer pricing adjustment, then compulsorily draft assessment order is to be provided, which can be challenged before DRP, and it is only after objections received from DRP that a final order will be passed by NFAC, and DRP proceedings are physical. But other than 144C case, if you are not eligible assessee, then there is no provision of draft order. Draft order happens only within the units behind the screen. Apart from 144B, various other enabling provisions have been made in the statute to either enable the faceless mode or to enable subsequent transition of various other proceedings to faceless mode subsequently. For instance, we have 157A, which also proposes that the CBDT has power to come out with a scheme to do rectifications in a faceless manner. As of date is done by the JAO, or it may happen on a faceless portal, but an entire scheme can be expected. Similarly, 264, that is revision. Revision as on date is happening physically, but there is a provision in terms of section 264A, which again empowers CBDT to come out with a scheme of revision of assessment orders in a faceless manner. So I have just cited certain other provisions where either to facilitate the existing regime of faceless to these provisions, or in future, for instance, 142B. So if a reference is to be made by the assessing officer to a valuation officer for valuation of a property, then while the reference will be made by NFAC, but that valuation happens physically by the valuation officer as on today. 142B enables a transition of even those proceedings in a faceless manner in future, as and when the will come out. Now, NF in this entire scheme of faceless assessment, National E-Assessment Center is the central mode through which we receive the notice or we give our reply. It is the National E-Assessment Center which acts as an interface between the assessing officer or the assessment team and with the assessee. And assessment team will comprise of assessment unit, which will be the assessing officer actually considering your replies, raising questions. If you need any assistance in terms of verification, for instance, if any cross-examination needs to be done, or it needs to be decided whether matter needs to be referred to the valuation officer or a specialist, then he can take support or may need to refer the matter to the verification unit. If any technical inputs in terms of law or any other important matter needs to be taken, then the matter needs to be referred to technical unit. And after all these three units do an assessment, they would need to pass a draft assessment order, which will be need to be given to the review unit, who will again give his inputs as to whether the draft order needs to be accepted as such or needs to be modified. It is only after the receiving the inputs from the review unit that the assessment unit will finalize the assessment order. So this is the various steps behind the screen through various units of the NFAC who are in a joint manner doing the assessment. This is what I have just encapsulated in that phase. Now, friends, 144B was originally introduced by TOLA and has been recently amended by the Finance Act 2022. There are certain significant amendments that happened between 2020 and 2022. I have only highlighted certain few important amendments that happened between these two acts. The first I have already briefly discussed, the communication of draft assessment order. In the original 144B, there was a provision of first providing a draft assessment order to the assessee, and only after receiving inputs of the assessee on that draft order that the final assessment order could have been passed. That has been done away with. The draft order is exchanged only between assessee unit and the review unit, but is not shared with the assessee. In the present regime, the assessment unit is only obliged to provide you with a show cause notice for the proposed adjustments to the income, to which the assessee can file its reply. So that is the first major change between the original 144B and the present 144B. The second is also a minor change. Earlier, 143.2 notice, there was a prescribed time limit of 15 days. As and when the 143.2 notice was issued, a 15 days time was given to the assessee to reply to that notice. That specified time limit has been removed, and now the reply has to be filed as per the time limit, whatever is given by the AO. Now, another important change, which is very important, and I'll be discussing it in detail in subsequent slide, is removal of subsection 9 from section 144B. This particular provision, erstwhile in the earlier 144B, provided that if there is any lapse in the procedure prescribed for doing faceless assessment, if it is not followed, then that assessment order will be considered as non-est, invalid in the eyes of law. That is, as if it was never passed. So, for instance, if the draft assessment order was to be given, if it is not given, and the final order is passed circumventing that requirement, then that final assessment order in terms of this provision was to be considered as non-est. For instance, if you had asked for a virtual hearing, and despite that it was not given, an order passed without giving that virtual hearing was to be considered as non-est in the eyes of law. This provision has now been omitted, and omitted not prospectively but with a retrospective effect. So even if prior to this omission, any assessment order was passed not following the procedure then prescribed, then because of the omission of this section, it is not to be considered as non-est. So the question would be arise whether passing of the order without following the procedure is a completely illegal order, or it is an order passed with some procedural defect which can be rectified. So that will be the question we will be discussing in subsequently. Then the other major change was provision of virtual conference. Earlier, the hearing was to be asked. The hearing was to be given at the discretion of the chief commissioner. It was not automatic as per the language of the earlier provision. That discretion has been taken away. Now, if the assessee asks for the virtual hearing, then it is mandatory for the department to provide that virtual hearing to the assessee. So that is the shift from earlier 144B to the present 144B in the statute. Now, having discussed the statutory framework, we will see stage by stage, from the stage of initiation to the stage of conduct of proceedings to the stage of passing of the order and then appeal, as to what are the important provisions relating to electronic assessment, what are the gray areas, what is the jurisprudence, and how it can be handled. So first, friends, very important issue that I'll be discussing is the meaning of issue and service of relevant notices through the electronic mode. Physical mode was simple. We could have known the date of issue either by the date of signature, or when it was given to the postal authorities, or when it was served by the postal authorities at your address. I think the law was fairly well settled during the physical avatar, but the entire mode changed in this electronic mode, and even there is insertion of various provisions prescribing for electronic mode of issue and service, tagging it with Information Technology Act. So and we know everything happens in real time. It is posted on the ITBA portal. You receive it on ITBA portal. You receive it by email. You may get an alert even on mobile. So what is the time when the relevant notice is issued? What is the time when the relevant notice is served? Will be the important issue of understanding in this electronic mode. And we all know the words issue and serve assumes a lot of importance. For instance, for the purposes of section 143(2), which is a jurisdictional notice to assume jurisdiction for assessment under 143(3), that notice requires to be served within the prescribed time limit. Earlier, it was 9 months from the end of the financial year in which return was filed. Now it has been substantially reduced to 3 months only. But what is important is it needs to be served within that time limit. If it is not served within that time limit, but service happens after that time limit, then the entire proceeding falls. So therefore, the issue of service, when service happens in an electronic mode, is important to understand. Similarly, section 148. 148, while does not require be served within the prescribed time limits, but it uses the word issue. That notice under section 148 needs to be issued within the prescribed time limit as per section 149 of the Act. So here the word is issue. What is the date of issue in case of electronic communication? We will see it later. But the summary of the discussion, if I can advance it, would be that issue and service are synonymous. It happens almost parallelly in the electronic mode, subject to certain exceptions. Now, what are the provisions relating to electronic mode of communication, service of notice or issue of notice under the Income Tax Act? We have a general provision of section 282 read with rule 127, which was there even prior to faceless assessment under 144B, and is generally applicable to issuance of notices or servicing that is happening outside the ambit of 144B. So, for instance, section 148, issue of 148 is not covered by 144B. 144B covers assessment. So, the issue of 148 notice will be governed by section 282. For faceless assessment, the provisions relating to electronic issue and service are covered within section 144B itself. So, for instance, section 282 says the service of a notice or summon or requisition or mode or any other communication under this act may be made by delivering or transmitting a copy thereof to the person therein named. Clause C. Now they ropes in some relevant provisions of Information Technology Act in the form of any electronic record as provided in Chapter 4 of Information Technology Act. So now, since the communication is happening electronically, so they have incorporated entire relevant provisions of Information Technology Act which deals with mode of communication electronically. Similar provision has been inserted in 144B relating to notices that are to be issued during the faceless assessment. That is, a notice shall be served on the assessee through the national faceless assessment under 142(1) or 143(2). 144B(6) is almost similar to 282, which says every notice or order or any other electronic communication shall be delivered to the addressee being the assessee by way of placing an authenticated copy thereof in the registered account of the assessee, that is ITBA portal, or sending an authenticated copy thereof to the registered email address of the assessee or his authorized representative. Even authorized representative is included over here, or uploading an authenticated copy on the mobile app of the assessee, which is presently not prevalent but may come in future, and is to be attached with all the three clauses of ABC and followed by a real-time alert. Real-time alert would be that if the notice is posted on your ITBA portal, it is alerted to you in real time on your email or on your registered mobile number. And again, it is linked to Information Technology Act. It provides that the time and place of dispatch and receipt of electronic record shall be determined in accordance with the provisions of Section 13 of the Information Technology Act. So the entire law relating to electronic mode of communication as to when it will be considered as issue or served, that is by placing on the ITBA portal, issuing mail along with real-time alert, has been prescribed in section 144B itself through its subsection 3 thereof. And then even registered email address is defined in that section only. That is the email address available in the ITBA portal or in the last income tax return or available in the permanent account number, Aadhaar number. In the case of addressee being a company, the email address of the company is available on the MCA website. any email address made available by the assessee to the income tax authority or any person authorized by such authority. So any of the latter available with the record of the department would be considered as a registered email address, and if any service happens at that email address, it will be considered as a valid service. Registered mobile number has also been defined. This is for the purposes of real-time alert coming to your mobile number. Now, what is the date of issue when it is considered as service has been borrowed from section 13 of the Information Technology Act. I'll briefly even touch this section. Section 13(1) says, save as otherwise agreed to between the originator, that is the income tax department, and the addressee, that is the assessee. The dispatch is issue of an electronic record occurs when it enters a computer resource outside the control of the originator. I think this has been elaborately dealt by Delhi High Court. I'll be discussing later. So the difference is that it is not when the department shoots it from their server. The importance is it will be considered as dispatch when it moves out of their server. That is, when it enters a computer resource outside the control of the originator, that is the tax department. That is the date of dispatch. Save as otherwise agreed between the originator and the addressee, the time of receipt. Now it deals with receipt of an electronic record shall be determined as follows, namely, if the addressee has designated a computer resource for the purpose of receiving electronic record, that is email, receipt occurs at the time when the electronic record enters the designated computer resource. So it is received when it enters my domain, when it enters the domain of the email address I have provided to the department or on the ITBA portal along with the real-time alert. If the electronic record is sent to a computer resource of the addressee that is not the designated computer resource. So, if, for instance, if it is given at an unregistered email address, receipt occurs at the time when the electronic record is retrieved by the addressee. So, if it has gone not to the registered address or a real-time alert is not given to the assessee, receipt will happen only when it is accessed by the assessee. So, automatic posting on the relevant portal is not automatically considered as the date of receipt, and this receipt will become important from the purposes of testing the time limit of 143(2) notice or for the purposes of testing time limit for filing appeal before the Commissioner Appeal, so on and so forth. So this is the brief of section 13 of the IT Act, which stands incorporated in the Income Tax Act through relevant provision of section 282 or 144(b)(6) of the faceless assessment provisions. Now, this exact entire controversy of what is the date of issue, what is the date of service, more particularly relating to 148 notice, read with section 282, was threadbare considered by Delhi High Court in this case of Sumanjit Agarwal, which was a batch of matter. Many matters were tagged along and a common judgment was passed. I'll just reiterate the key observations rendered by the court in that decision. The court said that generation of notice does not constitute issuance. So just because the AO has generated a 148 notice, has put it on the portal from its side, and there is a delay of it from moving out from his ITBA server to the assessee server, is not an automatic date of issuance of notice. Time has to be taken by the ITBA software for the purpose of deciding issue is attributable to the assessor, to the assessing officer. If there is a delay in moving out of the notice from the servers of the department, then that delay is attributable to the AE. It cannot be attributed to the assessee. So the relevant date and time of issue dispatch is when the notice leaves the ITBA server of the revenue. That will be the time it will be considered. It is not that when the assessing officer punches the enter button and he issues the notice from his computer, that will not be considered as the date of issue. It is when it leaves the exact date and time of the ITBA server that will govern the date of issue. We have recent cases from the High Court where even a 2-second delay, 2-minute delay, the court have come down that yes, it cannot be considered as being issued within the time limit and therefore it has to be quashed. It is a non-est notice. It is a notice beyond jurisdiction. So that is the exact time we need to see to check the date of issue, and that data is available at the ITBA server itself, which is available with the revenue. It can be given on the asking from the department. Now, the other issue that comes in is with respect to digital signatures. Two issues will come in: whether digital signature is at all relevant or not, or whether the date of digital, if digital signature is put, whether that date of digital signature will be relevant to consider the date of issue. The answer is that first, the date of putting digital signature is irrelevant to decide the issue. Issue has to be seen as to when it moves outside the server. So if the digital signature is put on, let us say, last date of 31st March, but the relevant notice moves out after 12 p.m. of that 31st March, that will be the date of issue, not the date of digital signature. Now, another thing will be if the notice is issued without carrying the digital signature and it is blank, but it contains the name and designation of the authority, the relevant DIN number is there, PAN number is there, but no digital signature is there, whether that can be considered as a valid or an authenticated document. The answer to that is yes. The answer to that can be found in section 282A2 of the Act, which gives authenticity to a document issued which is otherwise which otherwise carries all the ingredients of a particular notice, sans digital notice. It will be considered as a valid notice, which has been approved by Delhi High Court in this case also. But if the notice is issued along with digital signatures, date of digital signature will be considered as the date of signing of the document. So the relevance of the digital signature will be that it will be considered only as the date of signing. Now we come to service. We discussed issue. Issue is relevant mainly where the requirement of law is issue, like section 148. Now there are provisions which requires the relevant date or time limit for service of the relevant notice. The service happens when the notice is sent to correct email address or correct IDBA portal along with real-time alert. Then the same is deemed to be served on the date of dispatch/issue. So it is something like the jurisprudence which was available in the physical mode of sending notices, where the law was that if the notice is given to the postal authority, providing the proper address, the time of giving the address, if it is properly addressed and properly served subsequently, the date when you are giving to the postal authority will be considered as the date of service. So it is something like that if it is sent at a correct address, registered address, or put on the ITBA portal along with real-time alert, then when it moves outside the coffers of the department, that will be considered as the date of service. So in that sense, the date of issue and date of service will collide, but subject to the condition of real-time alert. If real-time alert is not there, then the notice will be considered as served only when the assessee sees it, accesses it, and that can be and the date of the email or ITBA portal can be viewed from the ITBA records, because everything is digitally recorded. So that will be considered as the date of service. So if in case of a 143(2) notice, which is to be issued within 3 months from the end of the financial year of the return filing, if by 12 p.m. of June 2025 it is not served along with the real-time alert, it will be time barred. It will be considered as served only when assessee accesses it. So friends, this is the new understanding of the law in terms of electronic communication, which we need to be aware of, which will help us in creating our defenses at the time of handling assessments for our clients to see whether the relevant notice, be it 143(2), 142(1), 148, meets the real test of time limit or the test of relevant dates of issue and service. We have certain other decisions which deal with certain other aspects of issue and service. Allahabad High Court Dauji Abhishan, which is almost similar to some Somanjit Agarwal, which said that date of digitally signing the notice or order not to be considered as date of issuance and service, and it will be considered as issue when it moves outside the coffers of the ITBA software of the department. The Bombay High Court said that if registered email is not available in the PAN database of the SSE, then it has to be physically delivered by speed post. So if there is no registered email address available, or it has become dysfunctional, then merely putting it on that dysfunctional email address is not relevant. But the AO will need to make an attempt to physically deliver the same by speed post, and then the normal provisions of section 282, which deals with physical service, will come into play. Same is Punjab and Haryana High Court, where again the Punjab and Haryana High Court quashed and set aside the relevant order by saying that merely placing it a notice on the e-portal does not fulfill the requirement of service, as it cannot be presumed that assessee would regularly check the portal. So since the assessee was not regularly checking the portal, and maybe it was not accompanied by a real-time alert, it was held that just merely putting it is not a valid service, and therefore they quashed it, sent the matter back to the assessing officer to redo the assessment of the relevant proceedings by doing a proper service. Yogesh Bansal, here the email address was registered of the earlier CA on which 143(2) notice was served. So the court held that since it was an earlier CA who is not an authorized representative anymore, it cannot be considered as a valid service, and therefore the notice under section 143(2) was quashed, giving the direction to the department to initiate fresh proceedings subject to time permitting. So we can see there could be numerous instances of lapses on the part of the department, which we need to be aware of, and then decide our defenses against the same, either by taking an objection or in appeal, or maybe as a last recourse by way of a writ petition before the High Court. As I briefed earlier, we can see that time and again the question of approaching the writ courts is increasing for defaults happening on account of understanding the valid modes of electronic communications. So this was with regard to issue and service. If there are any questions on this aspect, we can take it now, or we may take it later also, as may be decided by the host today. VP sir, any suggestions to that?
Hello.
Gaurav, it will be better you may complete, then questions and answer maybe at the end.
All right, sir. All right. Okay.
Okay.
Sure. Thank you. Now I move to another controversy which is quite active today, presently quite relevant, as to who has to issue a notice under section 148A or 148 by the jurisdictional assessing officer or by the faceless assessing officer. Before I come to the entire controversy, I'll just give a brief background. As I pointed out earlier, under the present 144B faceless assessment, there are certain exceptions. Those faceless assessment, that is where the jurisdiction lies with central circle or it's an international tax. If the assessee falls in the exceptional categories, then the entire assessment needs to be completed by jurisdictional assessing officer. In case of other assessees, the entire assessment needs to be completed by faceless assessing officer, that is NFAC. So the issue that arises is, and we all are aware that under the new 147 regime, which was enacted by Finance Act 2021, before issuing a 148 notice, preliminary interim opportunity proceedings need to be conducted under 148A. He has to give a 148A inquiry, 148AB show cause notice, 148AC reply needs to be considered, a 148AD order needs to be passed, and depending upon the AD order, proceedings needs to be initiated through issue of 148 notice. So the issue arises that if it's a case of a assessee whose assessment needs to be completed by a faceless assessing officer, whether these proceedings under 148A, including 148 notice, needs to be done by faceless officer or by the jurisdictional assessing officer. That is issue number one. The issue number two is whether in case of exceptional category of assessees covered by central circle or international tax, where assessment has to be completed by jurisdictional officer, whether in those cases also it is the notices are to be issued by faceless officer or by the jurisdictional officer. So this will be the issue in both category of assessees. That is the basic ethos of the controversy, whether the 148A and 148 needs to be conducted by FAO or by JAO. And the genesis of this controversy, friends, lies in section 151A, which empowers the CBDT to come out with a scheme for issuing 148 notices. So that's the source of the section. Under the source of section 151A, an e-assessment scheme 2020-22 was formulated wide notification dated 29/3/2022, which provided that both for assessment under section 147, it is reproduced on the slide in front, that which reads as follows: for the purposes of the scheme, the assessment, reassessment, or recomputation under section 147, the issuance of notice under section 148 shall be through automated allocation in accordance with risk management strategy formulated by the board as referred to in section 148 for issuance of notice, and in a faceless manner to the extent provided in section 144B with reference to making assessment or reassessment of total income or loss of the assessment. So with this notification, the issue arose that this provides issuance of notice under section 148 in all cases through an automated allocation system in a faceless manner. So while the assessment is to be completed under section 144B in a faceless manner, even the notice has to be issued in a faceless manner by the faceless officer and not by the JAO. So that issue emerged from the issuance of this particular notification. And now we have several courts, including contrary decisions from few other courts. So we have a divided house on this issue, whether a 148A notice or a 148 notice needs to be issued by a JAO or a FAO. Telangana High Court, Bombay High Court, Punjab and Haryana High Court, Guwahati High Court. So all these high courts have taken a view in favor of assessee, reading strictly the notification that in both categories of assessee, whether it falls in section 144B or in the excluded category, given the language of notification, which is mandatory for the tax officers, the notice under section 148 along with 148 proceedings needs to be conducted in a faceless manner by the faceless officer only and not by the jurisdictional officer. As opposed to these favorable decisions, we have contrary decisions also. We have a contrary decision from Gujarat High Court, a single member decision from High Court, and the latest decision, very elaborately written decision from Delhi High Court in this case of TKS Builders. TKS Builders takes a contrary view to provide that no, 148A proceedings can be conducted by the jurisdictional officer. They even don't see the strict reading of the notification as empowering the FAO only to conduct 148A proceedings or issue 140 notice. They give the rationale that when we see the entire scheme of assessment post faceless avatar, there is a mechanism of concurrent jurisdiction lying both with JAO and FAO in many instances. One instance is obviously, which is available, is that while the assessment is to be conducted by FAO, but rectification proceedings or a refund proceedings can be conducted by JAO. So there is a concurrent jurisdiction lying both with JAO and FAO. Section 144B8, if I remember correctly, empowers CBDT to transfer the case from FAO to JAO at any stage of the proceeding. And it happens practically in many situations, when department is issuing notice and there is no reply forthcoming from the SSE, or no service of notice is happening at the end of the SSE, then the NFAC transfers the matter from FAO to JAO to find the SSE, to serve him the notice, and then conduct the assessment. And then we have section 127 also, which empowers the CBDT to centralize cases, even in case of faceless assessments, to do a coordinated investigation. And we had that famous case of Sanjay Gandhi Memorial Trust to a political matter. But here in that case also, the trust case was transferred from a faceless officer to the jurisdictional officer, which was challenged by way of a petition before the High Court. High Court said that no, the CBDT has power. It is not mandatory that all the assessments can be concluded only in the faceless manner. It can even be transferred to the JAO. So, keeping in mind the scheme of the Act, which permits concurrent jurisdiction of JAO and FAO, that the High Court took the view that no, JAO can conduct the 148 proceedings. And why JAO ought to conduct the 148 proceedings, the High Court opined that the information which emanates from the risk management strategy, the information that emanates from the audit, the information that emanates from any investigation or inquiry is not controlled by the jurisdictional officer, but it is the jurisdictional officer who is privy to that information. That information comes to the JAO only, and it is the JAO who accesses that information. He is the one who will decide whether to act upon further on that information by issuing a 148A inquiry or 148AB notice, and then decide whether 148 proceeding needs to be conducted or not. So, taking cumulative effect of inherent concurrent jurisdiction with JAO and FAO, the information relating to 147 proceedings resting with JAO, the court took the view that we have to read the notification in the sense that that JAO is empowered to issue 148 notice. Up to the stage of 148 notice, it is the JAO who will conduct the inquiry. He will issue the 148 notice, and thereafter, the assessment will be completed by a faceless officer in terms of section 144D of the Act. And with that background, they even differed with other views of the High Court, which were strictly interpreting the notification. They said that no, when we read the notification in that light, it cannot be said that it is only the FAO who will issue the 148 notice. JAO is empowered to issue the 148 notice, and therefore they read the notification in that manner. And they also relied upon Gujarat High Court, which had taken a view that in case of such SSEs, the notices, since the 144D itself provides the assessment to be completed by JAO, the 148 proceeding also needs to be conducted by JAO and not the FAO. And they distinguish all the other favorable decisions of the High Court. So this is the summary of the controversy of JAO and FAO. Now we have a divided house, few high courts in our favor and few high courts against us. And Delhi High Court, from where I come, the High Court is against me. The matter is now pending before the Supreme Court and almost ripe for hearing, and is expected to be coming up in the month of December only. And maybe we can see the resolution of this controversy this way or that way. So we should look forward to that. But until that, I think when it comes to handling the issue, it is important that we keep the issue alive. We take the necessary objection in case the 140 notice is issued by JAO to await the outcome of the issue from the Supreme Court. Now, from the stage of issuance of notices, initiation of proceedings, I come to actual conduct of assessment proceedings in a faceless manner. I'll just give a brief overview how the ITBA portal look and how we should file the replies. I think many experienced professionals are already there, but for the sake of completeness, I'll run even through that aspects of the faceless assessment. The ITBA portal looks like this. It requires responses either in the manner of full response or partial response. Both are important, and I'll explain how in subsequent slides. Then it requires it asks you to click the nature of document which you are submitting by ticking that, and again it requires you to tick either as a partial response or a full response. Now the challenges which come while uploading the documents is the limit of the documents which can be filed along with reply, the limit of the files, as also the size of the files. So size of each attachment is restricted to 5 MB, and each reply can be complete only with 10 attachments. So that is a restriction. So in order to overcome that restriction, it is advisable to prepare one reply at a time which can accompany 10 attachments, rather than making an exhaustive reply having more than 10 attachments. You can use the tab of partial response, file one response as part under the category of partial response, and make 10 attachments to that, and then you can multiply the number of partial responses to overcome the limit of 10 files as also the 5 MB attachment. Now, having said that, this is completely procedural. What is important is the clarity of replies. Unlike physical mode of assessment, where we had the leeway of writing less, explaining more through personal interaction, that has since gone away. It is important that the reply should be crisp, clear, exhaustive, and not brief, so that the assessing officer gets maximum information with minimum words. So the requirement of good drafting comes into play when it comes to drafting of replies in the faceless assessment. We could have done away with good drafting in the physical avatar, but now we have to be very cautious. So apart from keeping the tab on this technical nuances of attachments, etc., I think what is more important is to abreast ourselves with good quality of drafts, uh, and see that the AO is not confused with the replies. Now, coming back to the defense by way of writ petitions, so in case we are not able to file our proper replies, I have cited certain cases which can come to our rescue, where the courts have held that if voluminous submissions could not have been filed on the portal, then the matter was set aside with the direction to the JAO to, to take the documents physically. So here is a case from Madras High Court, where on the portal, given the length and volume of the document which could not be uploaded, the assessing officer passed the order without considering or giving an effective opportunity to the assessee, passed the order, which was challenged by way of a petition before the High Court. High Court permitted the submission of those documents through the jurisdictional office. So this is again a mechanism where if we breach all the possibilities of filing the reply online, either apply to the senior officer under NFAC to permit JAO to take the physical submission only in exceptional circumstances, or take a rescue before the court. Now, in a case of Astra Enterprises, Madras High Court, assessee could not file the full attachment due to space constraint. The court set aside the assessment order to provide de novo opportunity to the assessee. So yes, while we need to endeavor to file all our attachments, but in case pushed to the shove, I think we can take rescue to the court. Now, when the assessment is over and a show cause notice is received, we come to the issue of taking opportunity of hearing only through video conferencing in faceless assessments. This power is vested in terms of section 144B6 clause 8, where only on request, that is the assessee needs to make a request for personal hearing, the income tax authority shall, I think the emphasis on the word shall, which makes mandatory to the income tax authority through faceless assessment center to conduct exclusively through video conferencing or video telephony, including any telecommunication application software which supports video conferencing with the procedure laid down by the board. So on asking of the assessee for personal hearing, it is mandatory now because of the use of word shall for the income tax authority to permit you that virtual hearing by any of the electronic modes. So what is important to be noted here is while it is mandatory, but it is mandatory only if you ask for it. If a show cause notice is issued and you file a reply without asking for the virtual hearing, then this clause will not be attracted. And I would like to share one case for which order is not readily available to me, but in that particular case, which was before the High Court, the assessee had written that I am filing reply to show cause notice. In case the assessing officer is still not satisfied, then an opportunity of personal hearing be accorded to the assessee. The High Court viewed that not to be a direct asking of the personal hearing. They considered it to be an indirect way of asking the hearing, a passive request of hearing, which, according to the court, did not meet the test of clause 8 of section 144b6. Rightly or wrongly, without going into that, I think taking clue from even such deviation by the High Court, what is required is that we should ask actively for personal hearing while giving our reply to show cause notice. Now, 144b6, friends, as we see today, gives a mandatory hearing, but this was not the position in the 144b just prior to amendment by the Finance Act 2022. As I briefly touched upon in my earlier slides, the erstwhile section vested the discretion with the relevant authority to give you the personal hearing by use of the word may on your asking. That may word has been replaced by the word shall. But despite the word may, the courts across the country said that the discretion is not at the ipsi dixi of the department, but when the assessee asks, then it becomes mandatory, even after the use of word may, for the department to give that opportunity to the assessee. And if that opportunity is not given, then it's a violation of principle of natural justice, and therefore the courts reversed the order passed without giving that opportunity. So even in that regime, when the word was discretionary, the courts reversed the assessment orders. Now when it is mandatory, and if we consciously ask for that personal hearing, I think the fate will be same, that the orders will be set aside. And this is the manner on the ITBA portal where we can ask for VC request. So there is a tab where we request for VC hearing, that is seek VC at the bottom of the screen, where we can click it. Then we will be given a link, and we have to do this formality of asking the reason for video conferencing. And on doing this, we will be given the link where we can place our request for virtual hearing. We will be given the link and we can conduct the hearing. So apart from all this formality available on the ITBA software, it will be advisable to parallelly ask or make that request in the accompanying letter or response to the show cause notice. Now the question arises, what happens if the video conferencing link made available to us is not properly working, or the hearing does not transmit smoothly for want of any technological difficulty? So obviously the answer is that yes, then it is not a proper opportunity of hearing. It misses the test of natural justice, and therefore the order passed can be said to be not passed, providing the opportunity. And we have certain cases to that effect where the hearing given was not found to be meaningful for want of either availability of the officer on the other side of because of the technical difficulty. Then it cannot be said that conference facility was given, and therefore the orders were set aside. The MP High Court says that request for hearing does not mean physical hearing. It will always be virtual hearing, and you cannot request for physical hearing. So the request will always be for virtual hearing and not physical. Now I come to the issue as to what happens if the assessment order is passed in contravention of faceless scheme, which is linked to my previous slides of virtual hearing. So, for instance, if virtual hearing is not uh, provided to you, or is not effectively provided to you, or the show cause notice was not issued, or earlier draft assessment order was not issued, what is the fate of those assessment orders? Whether they become barred by jurisdiction, they become non-est in the eyes of law, they become completely illegal. So the question is whether it's a jurisdictional error or it's a procedural error, where the lapse in procedure can be rectified. If it is a jurisdictional error, we all understand it is an illegal order, it will be quashed, and a fresh proceedings will need to be initiated by the department if there is time available. But if it's a procedural error, then the courts have power to set the matter back to the stage where the procedural defect happens. That is, till the stage where show cause notice was not issued. From there, the assessment proceedings can be continued. Or if the virtual hearing was not given, then the matter may be set aside to the assessing officer to permit you to give the virtual hearing and then pass the assessment order. So the proceedings do not get abated as being beyond jurisdiction. It is remitted back to the stage where the default occurred. So whether it is jurisdictional defect or procedural defect, that is the question we will be testing now. I think the first original 144B clearly provided in terms of subsection 9 that if there is any lapse in completing the assessment in the manner prescribed in 144B, then that order will be considered as non-est, as if such assessment is not made in accordance with the procedure laid down under this section. So the answer to the queries which I posed rested in subsection 9, which rendered the assessment to be completely non-est. And Bombay High Court in this case of Bantra Industries quashed the assessment order for want of not passing the draft assessment order and completely quashed, whereas other high courts and mainly Delhi High Court did not quash, did not invoke this subsection 9. Despite presence of subsection 9, they said that we will set aside the matter to the stage where inaccuracy occurred and permitted the assessing officer in most of the cases to correct the procedural defect occurred. Subsection 9 now stands omitted by the Finance Act 2020-22, but with retrospective effect from the date of insertion of Section 144B, as if it was never there in the statute. And therefore, what happened if an assessment was quashed by the court or any other appellate authority for want of subsection 9 at the relevant time? So Supreme Court, in the case of Mantra Industries itself, when the matter came before the Supreme Court, the subsection 9 already stood omitted from the act. Taking clue from that, the Supreme Court said that now, since subsection 9 is not there, the order cannot be considered as non-est, and therefore they permitted the department to file a review petition before the High Court to recall the matter, keeping in mind the subsection 9, and then decide the matter again. Similar can happen with CIT appeal. So if order was passed without following the mandatory procedure and you have taken a ground of it to be a non-est in the eyes of law, I think the CIT appeal can take cognizance of new omission of subsection 9 and either set aside the matter back to the AO or consider filling the gap of the opportunity not given to the assessee. But yes, as per the current scheme, it will not become non-est. But still, friends, the debate whether it's a jurisdictional error or a procedural error will remain, because the issue of violation of natural justice is embedded in our basic structure of constitution. We have cases galore across laws, Income Tax Act and other provisions also, that if any order is passed in violation of principal natural justice, it does not meet the doctrine of audi alteram partem, and therefore that order is an illegal order. So it is only depending upon the gravity of the non-compliance conducted by the assessee. I think the courts, higher courts, can take a view whether it's a jurisdictional lapse or a procedural defect. So this is what I wanted to discuss on the subsection 9 controversy, that even if there is a default committed by the AO, I think the courts can only at best set aside the matter back, giving another opportunity to the department to fill that gap. Now I come to another aspect of this faceless assessment, that is DIN. DIN controversy is also alive and burning, and the people in litigation would have seen many decisions of the appellate courts where either the notices or the assessment orders were quashed for want of DIN. But what is DIN, friends? DIN, for the sake of completeness, is a unique number, computer generated 20-digit unique number, which is required to be issued by the department as and when a system generated notice is issued to keep the audit trail to within the ITBA software, and it can be checked that it is issued by the system and by the correct officer. So that was the ethos of of uh, 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 of bringing the concept of document identification number. As I pointed out earlier, the reason for introduction of DIN was to maintain proper audit trail of departmental records and to bring accountability among income tax authority, in the sense that uh, no illegal notice is issued, which is not required to be issued, but is issued by the income tax department. In order to keep a check on that, the system of DIN was introduced. The where is this law relating to DIN? Friends, there is no section per se in the Income Tax Act which mandates the assessing officers to issue and code the DIN. There was a section 282B which was inserted in the statute by the Finance Act 2009, which statutorily mandate every communication with DIN, but that section did not see light at the end of tunnel, in as much as while it was inserted but remained ineffective till long time and was subsequently repealed by Finance Act 2011. The requirement of this DIN law was reintroduced not by the statute but through the CBDT circular number 19 of 2019, by virtue of the powers vested in the CBDT under section 119 of the Income Tax Act. Now, that circular said that it will be mandatory for every communication from the side of Income Tax Department that it shall be issued on or after 1/10/2019 with mandatory allotment of DIN number, and it needs to be generated and needs to be quoted in that communication. Only exception was if there was a technical difficulty in generating, allotting, quoting DIN, that it need not be quoted. Income tax authority who was to do his official duties outside the office is not required to quote the DIN, generate and quote the DIN. Delay in PAN migration, PAN of the assessee is not available. Functionality to issue communication not available in the system. So there were 5 exceptions in which case the DIN was not mandatorily required to be generated and quoted at the relevant time. But still, the reason for not generating the DIN was to be quoted in that particular communication, order, or notice prior to approval from the relevant chief commissioner. So that was the condition precedent even in those situations, and then it was to be subsequently communicated within 15 working days. So that is the law with regard to DIN, which made it mandatory for the tax authorities to issue DIN, to follow the procedure of quoting the DIN in the communication, or if it's in case of exception, then giving the reason and taking the prior approval, and then making up the gap within next 15 days. So while it's a mandatory CBDT circular, but where do we stand today? What is the issue? The issue is that whether CBDT circular can make it mandatory for the department to issue DIN or to invalidate the relevant communication in the absence of any statutory provision. Now, the larger issue is whether this is again a jurisdictional defect or a condonable mistake which can be rectified by the department by by generating a DIN subsequently in terms of section 292B of the Act. We had the landmark decision from the Delhi High Court, which settled all these controversies, which said that no, it's a jurisdictional defect. It is mandatory for the department to follow the CBDT circular. It is mandatory for the department to quote the DIN in strictly in accordance with the guidelines prescribed in the CBDT circular. And if it is not done, then in light of that circular, that order or communication is to be considered as non-honest or illegal in the eyes of law. But friends, this decision has been subsequently stayed by the Supreme Court. This matter is again pending before the Supreme Court. Having said that decision has been stayed, but it is only a stay on the operation of the order. But the ratio of the decision of High Court still remains. It is only the Delhi High Court which has been stayed. We have other High Courts, more particularly Bombay High Court and some other High Courts, where again this principle was reiterated. Those decisions are not stayed. So maybe the controversy of DIN remain alive in those jurisdictions, if not in Delhi, until the time the matter is settled. It is either affirmed or reversed by the Supreme Court. The Supreme Court, as is available in the public domain, entertained the SLP and granted a stay on the ground that it cannot be a jurisdictional effect, but it could be considered as a mistake on the part of the assessing office. And these are several other decisions. For want of time, I'll quickly touch upon certain important issues from these slides. I like to specifically point out this decision of Jharkhand High Court. Friends, when we will read the circular relating to DIN, it provides that the communication cannot be issued without the relevant DIN number. So again, the word issue becomes important. The point that arises is the facts which were there before the Jharkhand High Court, that the order was passed within limitation, that is 31st March 2022, by putting the DIN number, by signing, by putting the digital signatures, by signing the order, but the DIN was placed when the order was issued on the next date, that is 1/4/2022. So at the time of passing the order, the DIN was not generated. It was only when the order was being posted or was being issued or being served to the assessee that the DIN was generated. So the issue arose whether the order is invalid, because at the time when it was passed, the DIN was not generated. The court said that when we read the circular, it requires that the DIN needs to be generated at the time when it is issued to the addressee and not at the time of passing thereof. So therefore, it is to be issued, it is to be generated at the time of issue and not at the time of passing. And then we have several other decisions that if the procedure is not followed, if the condition is not written for generating the DIN, if the prior approval is not taken, then it is a jurisdictional defect. It cannot even be rectified by generating the DIN subsequently. We have several decisions, but now when it comes to Delhi jurisdiction or Delhi tribunal is concerned, having regard to stay being put by the Supreme Court, this issue is not being addressed, not being entertained by the tribunal, and is kept pending until the final outcome from Supreme Court. But again, having said that, till the matter is pending before the Supreme Court, it is incumbent upon us to remain alive of this issue, to keep this issue alive, take the necessary objections either at the stage of assessment or at the relevant appeal stage. Moving ahead, friends, few more instances or illustration. The issue arises whether a 144B assessment order, faceless assessment order, since it is under the supervision of Principal Chief Commissioner, so whether it can be said that the order is passed pursuant to approval of the higher officer and therefore it cannot be revised under Section 263. The answer to that lies in the decision of Bombay Tribunal in RDC Ventures, where they say that the senior officers are only discharging their administrative supervisory function while handling the faceless assessment. They are not undergoing the examination of issues while during the course of faceless assessment, and therefore it cannot be said that assessment order was passed after approval of a higher officer, which cannot be subjected to revision under 263. The faceless assessment orders can certainly be subject matter of revision by CIT under Section 263 of the Act. And who will conduct 263 proceedings? Considering the order is passed by the faceless officer, even that question is answered. It is the jurisdictional PCIT jurisdictional PCIT of the jurisdictional assessing officer, who that it is that person who can revise the assessment order. And similarly, the position with respect to appeals at ITAT or appeals at High Court or writs at High Court. It is the jurisdictional, the order may be passed by the FAO, the notice may be issued by FAO, but the jurisdiction of the appellate forum, be it ITAT or the High Court, will be governed by the jurisdiction of the assessing officer. Now, few illustrations that can happen in the faceless assessment is the assessee is not having PAN. So how, when there is no PAN, there is no ITBA portal, there is no availability of email, how will the notice be issued? How will it be put on the portal or on the email address? And same could be a situation of non-resident assessee. To my view, in case where PAN is not available, then it is the JAO where the jurisdiction will be transferred by the NFAC, and it is the JAO who will need to conduct the assessment in a regular physical manner, that is by service of notice at the physical address, or catching hold of the assessee, issuing its PAN, creating its ITBA portal, and serving the notices. So the answer to this kind of a problem would lie in switching back to physical assessment mode. Now, where assessment is completed for a person having no PAN, there is no remedy available to file the appeal, because appeal can now only be filed in a faceless manner on the ITBA portal. Even in that situation, if the assessee wants to file the appeal, he will need to obtain a PAN, create its portal, and then file the appeal against that assessment order. And assessment order can be uploaded physically, because if there is no PAN, the assessment order may not be available on the portal. But then how will you file the appeal? According to me, you apply for PAN, you create your ITBA portal, and in the ITBA portal, you upload the impugned assessment order. That could be the solution of challenging assessment orders passed without PAN. Gupta ji, should I briefly touch upon faceless appeals and take the questions, or is it the right time to pause and take the Q&A? So
you will take the appeals also for 10,
yes,
15
I'll
minutes.
briefly touch upon appeals. So on faceless appeal schemes, friend, I'll again deal with the legislative framework and how the appeal proceedings happen. There is nothing much different than what is there in faceless assessment scheme. But yeah, when it comes to legislative framework, subsection 6A, 6B, 6C of section 250 empowers the CBDT to come out with the scheme for faceless appeal mechanism, which has been introduced in forms of faceless appeal scheme 2020-22, which makes it mandatory to file appeals online, to accept the cases which are falling in exceptions. The appeal needs to be conducted in a faceless manner only. Again, it makes it mandatory for the CIT appeal to give you a virtual hearing only in case of asking. Then the exceptions of CIT appeals are again similar. The serious tax fraud cases, that is, which is emanating from search and seizure matter, international tax cases, even the assessment orders passed under the Black Money Act are not to be heard physically, but are subject matter of virtual hearing only. Virtual faceless appeal mechanism is again divided into various forms: appeal units, faceless mode of communication, automatic allocation of the appeal to the appellate unit in a faceless manner. Each proceeding relating to appeal, right from the stage of filing appeal, filing an application for condonation of delay, if there is delay in filing of appeal, if you need to raise an additional ground, if you need to file an application for additional evidence, if the CIT appeal needs to conduct any inquiry or investigation or even ask for remand report, each procedure is in a faceless manner without any physical interface. So everything needs to be uploaded on the portal, even in the faceless appellate regime. Even if the CIT appeal wants to initiate the penalty for enhancements done by the CIT appeal, that needs to be done in a faceless manner on the portal only. He will need to issue you enhancement notice. He will need to issue you a penalty notice. Everything needs to be done by the CIT appeal, but uh, in the faceless manner. Another important change that has happened in the appellate regime is insertion of section 246, which apart from CIT appeal, commissioner appeals empower JCIT also to handle certain class of cases in a faceless manner. The scheme of appeal in JCIT appeal is almost similar to the faceless mode of appeal scheme for CIT appeal. Almost all kind of orders can be decided by the JCIT appeal. The only difference is that uh, in a CIT appeal, the appeal is allocated to an appellate unit, who is a faceless officer. In a JCIT appeal, the officer is not faceless. You know the officer, but the mode of communication is purely uh, 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 faceless through the ITBA portal. There is no concept of physical hearing. The hearing needs to be requested only on a video conferencing mode only. So largely, all the appellate orders can be taken up by the CIT appeal, subject to certain amounts involved as enunciated in the scheme. That is, all the orders except uh, except assessment orders passed before 30th August 2020, having disputed demand exceeding 10 lakhs. So order passed before 30th 2020, demand exceeding 10 lakhs will need to go to CIT appeal and not to JCIT appeals. And this is the list. So, so in sum and substance, the assessment orders passed before 30th August 20 under 143.3 or 144, where the disputed demand is less than or equal to rupees 10 lakhs, in cases other than by mode of assessment or faceless, or appeals against intimation under section 143.1 without any disputed demand, can be decided by JCIT appeal. So this is a new procedure which is just to bring in the faster disposal, to quickly dispose appeals arising from 143.1 orders or having tax demand, can be taken up by JCIT appeals and be disposed fast. And on the practical front, if you ask me, the disposal at JCIT appeal level has happened more than at the faceless CIT appeal. The pressure on JCITs to dispose appeals per month is higher than the CIT appeals. Now, I think the major issue that needs to be addressed on faceless appeal is the pendency, and where I think the AIFTP and its allied class will need to come in to resolve the issue. I'm just quoting some numbers reported in the recent Gujarat High Court decision in Om Vision, October 2024. Faceless CIT appeals pending as on 26/9/24 are 3,90,878. Non-faceless only 80,000. JCIT appeals still better, 1,09,140. Total 5,80,188 appeals are pending as on 26/9/2024, out of which 3,90,000 is on account of faceless CIT appeal only. And I think most of you practitioners who are practicing on the appeal side, including Gupta ji, including me, since 2020, when this faceless appellate scheme came in, there is minuscule disposal by the CIT appeal. Even on a practical front, even the courts, rightly or wrongly, are not intervening and are not expediting the disposal of matters at CIT appeal. It is only, I think, through liaising with the government at the higher level by the associations like you that we can force the government to pressurize the officers to dispose the appeal. Maybe I'm not too sure what would be the reason of this non-disposal. It is either a conscious decision by the officers, or maybe they are helpless. Because, friends, the it is the physical interaction, it is the personal interaction which is always better. Because when we see voluminous documents are filed, even we as professionals need assistance from our team, from the assessees, to make us understand the matter and then represent it properly. So same way it could be with the officers also, that they are not able to understand the matter which are submitted online, and therefore which has resulted in paramounting pendency. So the issue needs to be addressed at the root. maybe with talking with the higher levels of the government by the bodies like you to understand the reason for this pendency and try to have the faster disposal. Friends, last but not the least, I'll touch upon a recent amendment in section 251 relating to powers of commissioner appeals, where earlier there was no power with the commissioner appeals to set aside the assessment back to the file of the assessing officer. They had to compulsorily pass the assessment, pass the appeal order deciding the merits involved in the appeal underlying. But now, only in case of limited cases where the ex parte assessment orders have been passed under section 144, that the power has been given to the CIT appeal to send the matter back to the file of the assessing officer to make a fresh assessment. So while this power is available, but we need to be conscious that if a jurisdictional error is committed by the assessing officer in passing this ex parte assessment, maybe that order cannot be set aside by the assessing officer, because if there is a jurisdictional lapse, that cannot be set aside back to the assessing officer. That order will need to go. The power of set aside available in this provision, in my view, will be limited only to give the fresh opportunity to the assessing officer, but not to correct the jurisdictional lapse. So this we may need to keep in mind while defending or attacking the CIT appeal orders, which are setting aside the assessment orders back to the stage of assessing officer. So with this was my overall presentation. I hope I made myself clear.
Thanks a lot. You have done very well, Gaurav. You have
Thank you.
covered almost everything, all the issues, and the quite good guidance also. So now we can take up the question answers.
Please, sir.
ये slide बंद कर दीजिएगा please. Slide बंद कर सकते हो गौरव?
Yes, sir. Am I audible? Yeah.
Yes.
Hello.
Yeah, please.
Yeah.
Tell
sir,
your name.
Sir, you said email is sent to the SSC, but it was not accessed. What is the position you said?
So it is only when you access that email, maybe at a later point of time.
Sir, maybe that happens after 6 months, and thereafter there's some time limit expiry will be there. Still, you say that when you access the email, that is only service?
Yes. So even if you do it 6 months down the line, that will be termed as service, because the question is that department will need to send you email along with a real-time alert, either on your email or on your mobile number. If that is not there, then it is not a service. It is only when you will access, you will get to know of that service at a later point of time. That will be considered as the date of service. You may file your appeal counting the time period of 30 days, or as the case may be, from that date.
Right, sir. Second question is, sir, a CIT appeal can ask for the remand report. This remand report is done by JAO or FAO, sir. How it is done?
Sir, it goes to JAO, but it will come through FAO. JAO will act as a nodal agency. Yeah. It will send to NFAC, and it is the verification unit. If any verification needs to be done, it will either be done by the verification unit, or the assessment unit will prepare the remand report.
Not by jurisdictional office.
Not by the JAO, not by the jurisdictional office. Because then JAO. it will indirectly defeat the purpose.
Yes, sir. Right, sir. It was
what cannot be done directly cannot be done indirectly.
Right, sir. It was excellent exposition, sir. Thank you.
My pleasure, sir. Thank you so much.
Next question. Anybody else?
Yes, sir. I have one question, sir.
Please tell your name.
I am Dr. Bhanugiri, advocate, sir.
Okay, welcome.
Sir, I have given my question in chat box also. My question is, under what circumstances the JAO can issue notice under section 148 without giving any opportunity to the SSE under proviso mentioned in section 148A?
No, so it is only in terms of explanation to section 148, that is the search cases or survey cases that 148A need not be issued. Otherwise, it is mandatory for the assessing officer to issue you either a 144A, 148AA, which is discretionary, but 148AB is compulsory. If the JAO issues you 148 notice, if the case is not covered by explanation 2, then that notice is illegal, bad in law.
Sir, my case is, my problem is there is a search, but third person's account were seized or whatever is there. No notice was issued to the third person, and the JAO directly issued notice under section 148.
So then you are covered by explanation 2, because if a incriminating material is found in case of a third party search, then it's a case covered by explanation 2, where department is empowered to directly issue the 148 notice. But yeah, I think what you need to check is that the material is incriminating. He has recorded a satisfaction that that material results in a detection of your income escaping assessment. If that approval satisfaction note is there, then there is no need for the department to issue you a 148A notice. But if it is not there, and just the material is not found to be incriminating in nature, it's a document, it's a disclosed document, then maybe it's a arbitrary exercise of power, you can challenge it. But it will depend upon the facts.
I asked them, sir. I asked them for the document.
They can issue.
I asked the JAO for issue of documents, but he has not provided. He said there was some cases, and your account was seized there. You have paid some amount of cash there, but in course of such, neither he was called for nor any notice issued to the third person, my client.
That may not be relevant for the search person, but yeah, in order to issue you the 148 notice, according to me, he need to have that document in place, and that document must be provided to you in discharge of the natural justice. And on practice, they record a satisfaction note approved by the senior officers. Only then they issue the 148 notice. If they are not doing, I think there will be some illegality involved, which can either be tested in court, or maybe you can take it subsequently in appeal.
Good.
Okay. Thank you, sir.
Next question, please.
Good evening, sir.
Yes, tell your name.
Sir, my name is Uday Bhatia.
Okay.
In one of my client's case, it is a partnership firm with an email ID which is not traceable, or not. Don't have the details about that email ID, and they have lately been issued a demand notice for 3 crores of rupees. They are not aware about the order being passed and any details about those things. And in that case, if that email ID is accessed today through some forgot password or other things, can it be communicated to the CIT appeal for continuation of delay that the email ID was accessed today? But how would the CIT appeal get convinced on that? Means, how would he agree ki you have accessed this today?
So, as I discussed in my presentation also, approved by Delhi High Court also, the entire log detail are available with the department in their ITBA system. So either you can ask for that details from the assessing officer, if that is and that ought to be provided. And on that basis, when that factual report will come in, that you have accessed the email only at that point of time, according to me, there will be no question of delay. You should file the appeal from 30 days from the date of that access.
Okay. Thank you so much, sir. Obliged.
Anybody else?
Good evening, sir. This is Gopalan Sharma.
Yeah, please.
Sir, in a matter where the court has set aside the matter under section 144B, there the subsection 9 has been referred by the court, and the assessing authority has not passed the setting aside order till now. The order was passed on the 10th of January 2023. Can this stand be taken that the order was non-as, since the court has already relied on that section, even though the same was passed in the year 2023?
No, okay. So in your case, court has already set aside the original assessment order for a de novo assessment.
Yes, sir.
So then that order, High Court order is in place. Subsection 9 remedy goes away. And now AO has to pass a order within the extended time limits as would be available under the relevant provision of section 153. So if that time limit...
That is 1 year. That is 1 year, but till now the order has not been passed.
So if time has lapsed, then the proceedings become barred by limitation. If time is available and they pass the order in that time limit, then that order is certainly valid.
No, it has, the time has already been passed. So can we take
So
that?
the order has become barred by limitation. You can challenge that order. Yeah, it is illegal order. If any order will be passed, it will be an illegal order. You need not do anything on merits. You can challenge the order straight away.
We can go through the faceless and any notice issued by the faceless that it can be objected by that that technicality.
Yes. Yeah. You can take the technical objection that the notice, if any, now issued is beyond limitation.
Okay, thank you, sir.
Anybody else? Any other question?
Sir, I have one more question.
Yeah, please.
In this case, 148 was issued without DIN number.
Okay.
But on the same day, by late evening, they issued a separate letter communicating that the 148A, the DIN number is so and so, so and so. Is that 148 still valid?
As per the circular and by various other decisions of the courts and tribunal, there is no permission to the AO to issue DIN through a separate letter. So that letter is invalid in the eyes of law. But yet, yes, we will need to see the fate of this controversy as per the Supreme Court decision, because now the matter is finally resting with Supreme Court. But the current decisions which were rendered prior to the stay, the courts were quashing that there is no permission to issue the DIN by a separate letter.
Okay. Thank you so much, sir.
Sir, may I ask one more question?
I have one question.
Sir, I have two questions.
Yeah, please.
Myself is R.D. Kakra.
Kakra Sahab, yes. Kakra Sahab हमारे जनरल सेक्रेटरी हैं जी.
नमस्कार काकड़ा जी, प्लीज.
नमस्कार गौरव जी. आज का आपने डेलिब्रेशन से जो गौरव मिला है उसके लिए आपका बहुत बहुत धन्यवाद, पहली बात. और दूसरी बात, हमारा क्वेश्चन सर ये है कि सर 148 is issued and reopening is made on 360 degree communication received by the AO regard to the property from ARA. Now that property is someone misused the Aadhaar card and by that way sold the property. Now I reply to the AO in Faceless that this is a same transaction. We have not did any transaction. My associate has not did any transaction. He asked and filed the police case, FIR, against the person concerned. Now in 142 one notice, he is asking about the status of the case, and I, in reply, given to the order of the court that this is that this is not a good transaction, and in title suit he convinced and cancelled the deed and allowed the degree in favor of my SSC. Now that paper is given to him. My question is that whether after that AO is asking the bank statement, all the bank statement and accounts, whether it is valid. May I comply that? I'm not supposed to comply that.
No, sir. I think yes, to the extent of transaction, you have explained him validly. But once the 148 proceedings are initiated, then the scope of assessing officer is not restricted to the information on the basis of which he had initiated the proceeding. It expands beyond that. And there are specific provisions to that effect in the section itself. So he is fully empowered to verify other transactions also. And nevertheless, he is also empowered to check whether this transaction actually happened or not. If there is any banking transaction for this particular property at your bank. So on multiple front, according to me, he is empowered to do that. But if after providing the documents, no banking transaction relating to property is found, coupled with the court order which you have placed on record, at least this transaction, to my mind, he will not be able to make any adjustment to that effect. That he will have to drop.
Whether he is confined only to the property transaction or other transactions also.
He is fully empowered to verify other transactions.
Okay, sir. My second question is that, sir, regard to the appeal. The appeal is pending. The appeal order in response to NFSC. There are 3 to 4 times I submitted the all the documents, but still the order is not received by the SSC.
That is
More than 4 years.
that is
than
not
4 years.
the position in your case. That is the position almost in every case.
Every case.
Okay, sir. Okay.
Yeah.
Now, sir, undoubtedly today's virtual webinar.
In chat, एक minute. In chat box there is a question that how to go about the submitting of additional evidence to CITA in faceless manner.
So I think the answer is same. We have to file an application for additional evidence in terms of Rule 46A. We will have to make out a case as to where was the lapse in not filing the additional evidences at the time of assessment in that application. But that application now need to be filed online. The only difference is earlier we could have filed physically and argued that application. Now it is to be filed online. And all the arguments relating to its admission shall happen at the end, as and when the opportunity of virtual hearing will come in.
Yeah, very good.
Sir,
I hope there is no other question.
Hello.
Please, Sanjeev Rao. Please, Sanjeev Rao. Yes.
साहब एक चीज है कि मैंने स्पेसिफाइड अथॉरिटी से सेम डे में परमिशन लेके जाओ इश्यू कर सकता है ऑर्डर 148A डी।
नहीं, एक दिन में कैसे करेगा ना, पहले 148 में तो उसको टाइम देना ही है 15 दिन का।
नहीं, एक दिन में परमिशन लेके बात कर रहे हैं, सेम डे परमिशन लेकर के ऑर्डर। Yes, of course, that can
ले तो सकता है। The only question will be whether the approving authority has applied mind. So you will have a good ground. If the issues are humongous, you can certainly take a defense that there is lack of application of mind in giving the approval in one day. So it will depend upon the wording of the approval. If the approval wording is silent, sub-silent, then and it shows lack of application of mind, you have a good defense. But if the wording says something more, which shows application of mind by the approving authority, merely because he is taking in one day, I think you will not have a defense.
Thank you very much.
Sir, just
one question.
Hello.
Yes, please.
Yeah. Sir, just discussing academically, as you said, this DIN number is because of the circular. So can the court say no? It is just not by statutory provision. So how do you see this case to move further, sir?
Okay. No, I don't think, because the circular has it may be a circular, but the circular has a statutory backing in terms of Section 119, which makes it part of the Income Tax Act only. So I think that will not be a ground of rejection, if at all, by the Supreme Court. I see it more as seeing it by the court as a jurisdictional error or a procedural error. So the difference between both is jurisdictional error cannot be rectified by anybody. It goes to the root of the matter. But if it's a procedural error, then that procedure can be rectified by making available that procedure again. So the larger debate would be whether it goes to the root of the matter or it's a procedural defect which can be rectified.
No, because I said, sir, the circulars are not binding on the court.
No, so they may not be binding on the court, but they are binding on the revenue officers. So it is the revenue officer who has conducted a lapse of not issuing the DIN. The courts are testing the action of the revenue officer, which has happened for lapse of DIN. So certainly the circular is binding on the revenue officer. But the question that will arise is whether the lapse by the revenue officer by not following the mandatory circular makes it a jurisdictional defect or just a procedural defect that can be rectified. That is the larger question.
Sir, may I ask one question?
There is a question in chat box also. Cash deposit as per AIR information, AO written in the order unexplained income without quoting any section. Can it be taken as a order is illegal?
I think the house will be divided on that. According to me, section can certainly, if not by the AO, when you will go in appeal, CIT appeal can certainly impose the section because his powers are coterminous to that of the AO. And he is deciding the appeal and he's a fact-finding authority. So it may not be a jurisdictional error on the part of the AO. He may have just missed mentioning the section, which does not go to the root of the matter. If it is argued, it goes to the root of the matter. CIT appeal can certainly correct it.
Right.
Sir,
Any other question?
Sir.
Yes.
May I ask one question, sir?
Yeah, please.
Jain sir, can the assessing officer disallow the expenses under section 153A, read with section 143.3, without mentioning any incriminating documents being found during the course of search and seizure?
No, I think the law is settled now. You can refer to Supreme Court decision Abhisar Bildwell that in case of concluded assessment, you need to see whether that year is a concluded year or an abated year. If it's a concluded year, the AO cannot do a ad hoc disallowance. Dehorse the.
This is abated. This is abated. But in view of section 143.2, when the notice was not issued timely, can it be taken that this is the unabated assessment?
No, it is a concluded assessment. If 143.2 was not issued and the time for issuance of notice had lapsed prior to date of search, then it is not a abated assessment, it's a concluded assessment.
Then this Bildwell will apply.
Yeah, Abhisar Bildwell will apply.
Okay. Thank you, sir.
I think there is no other question. So may I request Hardik Agra Gupta ji, there is a question from Pirgal. Yes. Assessment is the box they are writing. Yes. What is the question? I am not able to see.
Sir, I am also having one question.
Yes.
Sir, actually what happens in the CIT appeal, matters goes to various different CIT appeals. The matter related to one property only. So different views are taken. So is it possible that it could be clubbed to one CIT appeal NFSC?
I didn't follow how we cannot even know if it has moved to different CIT appeals. Is it a physical or a faceless appeal?
It's a faceless appeal, sir.
So in faceless appeal, we do not even know whether it has moved to any CIT appeal or not.
If we have opted for a virtual hearing, and while the virtual hearing, the particular CIT appeal says that you can move an application with me, that you can club the other matters with me also. Is it possible that we can move an application to CIT appeal so that he can club through any of thing? Is it possible like that, sir, or not?
I don't think so, sir.
Or else application
my view would be negative.
Portal, or else we can. Is it possible that we can make application a particular portal so that it would avoid a multiplicity of litigation actually?
In fact,
I think application can be made to the Chief Commissioner and FSC, and it will be at his discretion to consolidate or refer, but you don't know. You will not know to where it has gone. Probably your question is that there may be different assessees, in which cases the issue may be of relating to the same property.
Yes,
say maybe husband, wife, or maybe brothers, or like that. So probably that is your question.
Yes, sir.
Yes. So you can yes. Pradeep, please.
Sir, a question.
Please.
सर मेरे केस में एओ ने 2018 में एसएससी का केस डिसाइड कर दिया और 2018 में एसएससी की कोई ऐसी घर में एक्सीडेंट हो गया, वो छोड़ के चला गया था। अब 2024 में जाके उसने कहा कि अपील करनी है। जब बार बार नोटिस आ रहे थे तो मैंने सारा स्टडी किया, सारे नोटिस असेसमेंट ईयर 11-12 की पोर्टल पे थे, बट दी ऑर्डर पास अंडर 144 वो नहीं था पोर्टल पे। तो मैंने एओ को लिख के फीस डिपॉजिट करके एप्लीकेशन डाल दी कि प्लीज फर्निश द 148 notice as well as the 144 order along with the proof of service on the SSC, because we are in the process of filing the appeal. अब क्या एप्लीकेशन के बाद एओ ने क्या किया, एओ सिर्फ एप्लीकेशन के बाद उन्होंने मेरे को 144 ऑर्डर की कॉपी दे दी, भेज दी ऑनलाइन, बट कहता वी डोंट हैव एनी प्रूफ ऑफ सर्विस, हमारी फाइल में कुछ नहीं है, अगर आपने इंस्पेक्ट करना तो कर लो। बट इन दीज केसेस हाउ द डेट ऑफ सर्विस विल बी?
सर इसमें दो इश्यूज हैं। एक तो assessment order के लिए what is relevant is date of passing.
Yes.
This can happen later also. So what you need to check is whether that order is passed within the time limit, outer time limit in terms of 153. That is would be the relevant year, 31st December of the relevant year or not. If it is signed and passed on that date, then service is happening to you today.
Okay.
So service can happen late also. It is happening to you today. So from today you can file your appeal before Commissioner appeals.
सर ऐसा है ना कि एसएससी ने तो बोल दिया ठीक है, एज ए नॉर्मल प्रूडेंस हम समझेंगे कि वो उसको वो कहता नहीं मिला, लेकिन मान लो कल सीआईडी अपील से आ जाता है एओ को कि वो उसके बाद कोई रजिस्टर दिखा दे और एओ के किसी रिश्तेदार के पास डिलीवर हुआ हो, तो इन दैट केस फिर क्या होगा?
Then you will have to apply for condonation of delay, that it was a bona fide mistake for health reason or medical reasons.
Yes.
It was received by some relative and not by the assessee, and he was not keeping well, so therefore he could not take any action. Well, that could be a ground for seeking condonation of delay.
नहीं, but now at this stage of filing the appeal, अब क्या date of service क्या लेना? अब
नहीं, so that's what I'm saying. There will be two situations. It is the factual matter.
Yes.
If it is served originally,
yes,
either to your authorized representative or somebody at a right postal address, then that is the date of service. There is a delay, you apply for condonation.
Yes.
If he is not able to prove any correct proof of service to a right address, and he is serving you today at the right address through the right authorized representative or to the assessee, then date of service will be today. From today, you can count 30 days and file the appeal.
सर ये तो ठीक है बात, लेकिन अब एओ नहीं ना क्लियरिफाई कर रहा। वो कहता है जी हमने ऑर्डर कर दिया था, ये रजिस्टर का नंबर है। अब वो क्लैरिफाई नहीं कर रहा, एओ नहीं बता रहा, क्योंकि मैंने तो एप्लीकेशन डाली है, लेकिन उसके रिस्पांस में एओ ने वो सर्विस का प्रूफ नहीं दिया, बस वो कहता है ऑर्डर पास्ड है।
So you have 2-3 remedies to that. Maybe Gupta ji can also supplement to my answer. You can seek inspection of record. You can file RTI. RTI, it is mandatory for the department to give you that date along with the evidence. Even if both fails, obviously in RTI you have further recourse to appeal under RTI. So 90% it will be resolved in RTI also. Third, you file the appeal. You take recourse of CIT appeal, and CIT appeal, while adjudicating your ground, will get that record.
Okay. Thank you, sir.
Pradeep, as you mentioned, that he is saying that you see my record, there is no proof. So
yes,
you should inspect the file, and on the basis of the affidavit, you can file before the commissioner that there is no proof of the service, so it has not been served, because at that time it was supposed to send by post.
सर ऐसा है कि वो फाइल में
जस्ट अ मिनट प्लीज।
सर मैंने एप्लीकेशन डाली विद उसको ईमेल की विद फीस, विद प्रिस्क्राइब्ड फीस, कि मेरे को डेट ऑफ सर्विस बताएं। फोन पे भी बात होगी, वो कहता है जी हमारी फाइल में तो सिर्फ वो रजिस्टर का नंबर लगा हुआ है जिसमें हम एंट्री करते थे, उसके बाद स्पीड पोस्ट होती है, तो हमारे ऑर्डर पे वो नंबर लगा हुआ है रजिस्टर का। अब रजिस्टर से होती है स्पीड पोस्ट। अब स्पीड पोस्ट वाला हमारा रजिस्टर हमें मिल नहीं रहा, हम आपको कैसे बताएं? हो सकता है कहता है कल को रजिस्टर मिल गया तो हम बता देंगे कि हमने स्पीड पोस्ट की थी, तो हमारे एंड से कहता है वो सर्विस हो गई। अब एज ऑन डेट कहता है कोई स्टेटस हम बता नहीं सकते, जब हमें रजिस्टर नहीं पता। हमारा रजिस्टर मिल जाए 18 का, कहता हम बता देंगे। अब
फिर इस सिचुएशन में तो जैसे गौरव ने सर्च किया, आरटीआई लगाओ, आरटीआई में यू शुड सी क्या रिप्लाई, उसके बेस पे एक्शन।
May I add to it, sir?
Please.
File a protective condonation application.
नहीं, उसमें दोनों तरफ दिक्कत आ जाएगी।
All the
पहले तो
service is not been
नहीं,
made,
पहले
but
आरटीआई पहले आरटीआई लगा के उसमें एविडेंस लेने की कोशिश करो, और जो उसके बेस पर करना चाहिए।
नहीं सर, आरटी तो ठीक है, मान लो जो मैंने एप्लीकेशन मेल की, मेल में भी मैंने यही बात लिखी, आरटी में वही लिखनी है, फीस डिपॉजिट करा के मैंने मांगा।
आरटीआई में ही सपोज टू रिप्लाई यू, अभी तो वो रिप्लाई नहीं कर रहा।
नहीं कर दिया रिप्लाई। रिप्लाई क्या किया, मेरे को 144 ऑर्डर मैंने मांगा था विद सर्विस प्रूफ, और 148 नोटिस विद सर्विस प्रूफ। उसने लिखा कि विद रेफरेंस टू योर ईमेल रिसीव्ड वी आर क्लोजिंग हियर विद 148 नोटिस एंड 144 ऑर्डर।
नहीं, फर्क हो गया ना प्रदीप जी। जब आप आरटीआई में बोलोगे, आरटीआई में आप उससे बोलोगे कि मुझे प्रूफ दो, और अगर आपके पास प्रूफ नहीं है तो क्यों नहीं है, आप इस तरीके से क्वेश्चंस पुट अप करोगे। He will have to answer that questions mandatorily. अभी तो उसने खाली वो 144 ऑर्डर लगा के भेज दिया। आरटीआई के जवाब में वो बताएगा मेरे पास प्रूफ नहीं है या मैं एक्सेस नहीं कर पा रहा, तो उस बेसिस पे यू कैन डिसाइड योर स्ट्रेटेजी। देन यू मे फाइल एन एफिडेविट कि भाई हमारा मेरे को मिला ही आज है।
तो अभी फिर अपील को ले कर ले, अभी फाइल ना करें, इट इज रिकमेंडेड कि पहले
आरटीआई के बाद डिसाइड कर दो कॉन्डोनेशन के साथ जाना है या विदाउट कॉन्डोनेशन जाना है।
ओके, थैंक यू सर, थैंक यू वेरी मच।
प्रदीप जी सर, काइंडली आई वुड लाइक टू ऐड, आप तो ये ग्राउंड लीजिए कि जब आपको मिला नहीं ऑर्डर का कॉपी, आप ये ग्राउंड लीजिए ना कि आपको ऑर्डर मिला ही नहीं। आप जब आरटीआई में लिखो तब ये लिखो कि भाई हमको ऑर्डर मिला नहीं, यदि डिपार्टमेंट ने सर्विस किया है तो हमको प्रूफ दो या डेट बताओ। आप सबसे पहले ये लिखिए, पहला सेंटेंस, हमको मिला नहीं।
ओके, तो अपील को उसके बाद डिसाइड करें फाइल करने का, पहले ये करें।
मिला नहीं आप ये ग्राउंड लेते हो तो आप अभी असेसिंग ऑफिसर से उस ऑर्डर की सर्टिफाइड कॉपी मांगिए, तो आपकी डेट ऑफ सर्विस वो होगी जब वो आपको सर्टिफाइड कॉपी देगा।
ओके,
वो जैसा वो तो दे दी ना, उसे सर्टिफाइड दे दी,
वो तो दे दी सर, बहुत
उस बेस पे अपील तो आप कर दो मेरे ख्याल से।
हाँ बिल्कुल,
उस डेट को रिसीट मान करके अपील कर देनी चाहिए।
गुप्ता जी हैज राइटली एडवाइज्ड
सर, लेकिन क्वेश्चन ये है,
जाएंगे फिर दिक्कत आएगी, और इन द मीन टाइम आरटीआई में लगा दो आप।
सर मान ये अगर मैं कर तो देता हूं अपील उस बेस पे, क्योंकि कॉपी थ्रू ईमेल प्रॉपर आई है, लेकिन इशू ये है कि किसी पार्ट पे अगर लैब्स कल को वो रजिस्टर के में कोई एंट्री हुई और कोई ऐसा प्रूव हो गया सीआईटी के बिफोर सीआईटी इट वाज प्रूव्ड कि ऐसा उनको मिला था, किसी रिश्तेदार को दे दिया, बट इन दैट केस फिर क्या करेंगे?
प्रदीप जी, रिश्तेदार को दिया गया जो है प्रॉपर सर्विस नहीं है,
प्रॉपर सर्विस नहीं है,
रिश्तेदार को दिया है, दैट इज नॉट ए प्रॉपर सर्विस, सो डोंट वरी।
ओके, ठीक, थैंक यू।
और वो बात की बाद में देखना। So I think it was an excellent deliberation, and Gaurav has handled the questions and answers also very well. I'm very much thankful to. May I request R.D. Kagra Sahab to give a vote of thanks, please? Kagra Sahab.
Friends, at the outset, I like to thanks our National President and Taxation Committee Chairman Gupta Sahab for their efforts and selecting a appropriate Kohinoor speaker for today's practical virtual webinar. Undoubtedly, we all the participants immense benefited from today's webinar, and many tricky questions were answered by Mr. Gaurav, and for that we thanks to Mr. Gaurav Jain. एंड आज का यह वेबिनार गौरवपूर्ण भी रहा और गर्मियों में भी रहा। हम धन्यवाद देते हैं। धन्यवाद।
थैंक यू गौरव, थैंक यू एवरीबॉडी, इट वाज माय प्लेजर। थैंक यू गुप्ता जी अगेन।
बाकी subsequent seminar please announce, Gupta ji.
That is what I'm saying. I may inform that on next Saturday we'll have another Zoom seminar addressed by Dr. Ravi Gupta on the provisions of capital gain, particularly amendments made in 2024.
Excellent.
On next Saturday, same time, 5 o'clock to 7 o'clock. Please note.
सर उसके बाद में एक विवाद से विश्वास जो है, इसके ऊपर भी एक सेमिनार करेंगे। उसके लिए अप्रोप्रिएट स्पीकर हैं जालंधर के, मैं आपको नंबर दे दूंगा, आप कांटेक्ट कर लीजिएगा।
भाई साहब, हमारे पास टाइम लिमिटेड है, दिसंबर तक का। हमारी जनसभा की टर्म दिसंबर तक है। चलो करेंगे वो
शनिवार करते रहेंगे अपने।
करेंगे
अभी 4 शनिवार और आएंगे
हमारे आगे तक। शनिवार बुक हो गए
सर विवाद
थैंक यू
हमारे सब शनिवार बुक है।
ठीक है
डिस्कस कर लेना। विवाह से भी शादी
Okay, thank you. Thanks a lot, Gaurav. Thanks to everyone for joining.
Thank you, Jain sir.
Thank you so much.
जलंधर वाले का क्या नाम है सर उसका?
Thank you very much.
है जी?
जलंधर वाले का क्या नाम है उसका जो स्पीकर बोल रहे हैं VSP पे?
Thank you, sir. Thank you.
चलो बात कर लेते हैं, बात कर लेंगे।